Let's bring in our guests, still with us, criminal defense attorney David Bruno and former homicide prosecutor Melba Pearson. There's some interesting issues raised here. But first and foremost, one of the arguments made by the judge and by the attorney general is that this Sixth Amendment right, now what they're talking about is the fact that these attorneys were removed means that the trial date was moved almost a year. So this is an innocent man in jail, and he's presumed innocent, but has to sit there for another year because of this removal. But the judge has complete discretion as to whether she wants to remove them for gross negligence. She said she exercised that. David Bruno, where do you stand on this?
Oh, wow. What a web here. Honestly, I think there needs to be some really responsibility for the leak. I mean, that's what the judge and the prosecutor standing on is saying, that they're removed because they didn't maintain the confidentiality of evidence, that the evidence was sent to a party that did not have the appropriate authorization to get it, and that false information was provided to the court. So if those things are true, I think there is an argument. But at the same time, does it cut against the right of a defendant? I mean, it's not as if it was a conflict of interest. It's not like these attorneys represented the victims or gained specialized knowledge for something that they didn't have access to. This is a very, very close call. And I would imagine that the court should probably err on the side of caution when they say, okay, he should get his counsel, absent egregious conflict of interest that go to the quality of the representation.
Yeah, now they address that issue as well, this Sixth Amendment right to choose your own counsel, have the lawyer of your choice, and they cite something similar. They say there's no law that says the judge has to wait or delay the removal for incompetence until it ruins the whole trial. And that's exactly what you're talking about. If you see it early on, the earlier you get rid of it, the less of a problem it is down the road. What's interesting as well, the judge argues, is that the defense doesn't really allege any kind of bias. And that's what's required here. They don't give a reason why the judge would have done this other than for the reasons she states, the gross incompetence and the negligence by the attorneys. And without that, they don't have a leg to stand on, David.
Yeah, the other issue, Michael, though, is that the counsel withdrew. It wasn't a court order that removed them. And now they're going on to say that they were forced out by the judge. There's a little gray issue right there as to how that happens. What was that communication? I mean, that's not the appropriate way to order an attorney to withdraw. It's not done in chambers, back channels, and it's not through pressure. So that's another issue there. I see it going both ways, because not only could this be an issue at trial, but to take an attorney away from the defendant and then later be convicted, well, that's going to be an issue on appeal too. So good thing that the Supreme Court has this issue, because they could really make a decision that may not come back later on appeal through that same channel.
Yeah, and I think when you read the minutes of the meeting with the attorneys and the judge, it's clear that they were pressured into it. They were aware disqualification was on the table, but the way it was put to them in that meeting, that they had to do it that day, make a decision, I think was definitely a little bit problematic. So we'll see how the Supreme Court looks at this whole issue. All right, stand by, guys.